Hello, and welcome to this session on forfeiture of leases on the ground of non-payment of rent, which I'll be presenting for Legal Futures. I'm Mark Shelton. I'm a non-practicing solicitor and commercial property management law trainer. I used to be in practice with Linklaters, DLA Piper, and Evershed Sutherland. So, forfeiture of the lease can be one of the most immediately effective remedies for non-payment of rent. The tenant turns up one morning to their business premises whistling a happy tune and finds that the locks have been changed. No warning. The only way they can get back in is to pay the arrears. Now, forfeiture may result in getting possession back, but if it does, it doesn't necessarily mean that the landlord is going to get paid. Also, the landlord is exposed to the tenant or subtenant making an application for relief from forfeiture for quite a lengthy period. That can get in the way of reletting. And to make things worse, the rules around applications for relief are very technical, in places not very clear. So we're going to explore these issues and some others, and we're going to identify the key points to be aware of to try to get the result that the client expects. I should say, first of all, that the ability to forfeit leases for non-payment of rent was suspended under Section 82(1) of the Coronavirus Act of 2020 as part of the government's response to the COVID-19 pandemic. Of course, it was reinstated over a year ago with effect from 24th of March 2022 in relation to all arrears not covered by the compulsory binding arbitration scheme under the Commercial Rent Coronavirus Act of 2022. That scheme has almost completely run its course. I understand there are one or two arbitrations still outstanding, but hardly any. So basically, forfeiture is now available in relation to all arrears other than any which may be the subject of an outstanding unresolved arbitration under that scheme. So, first of all, I suppose basic question is, well, what is forfeiture? Forfeiture simply means termination of the lease by the landlord in reliance upon some default in compliance with its lease obligations by the tenant. Um, as regards business tenancies, which fall within the Landlord and Tenant Act 1954, Section 24(2) of that Act provides that forfeiture is one of the common law means of termination of a tenancy, which is still effective, notwithstanding the provisions of the Act. So, having forfeited, of course, there's no ability for the tenant to renew or to serve a Section 26 request or anything of that sort.